Hello, everyone, and welcome to APS Webinars. The title of today's webinar is Understanding IP from Patents to Publications to Trade Secrets. I'm Crystal Bailey, and I'll be your host for today's broadcast. Thank you all so much for joining us. APS Webinars are brought to you as a service of the American Physical Society, connecting you with the expertise of individuals who can offer insights into physics careers, educational programs, and professional development for students, working physicists, and educators. APS membership gives you easy access to valuable career information and resources, such as this webinar, allows you to present your research and network with potential employers or colleagues at our meetings, and get involved in issues that are important to you through grassroots advocacy. It can also help connect you to a community of like-minded folks through participation in our forums, divisions, and topical groups. If you are not yet an APS member but value the things that APS provides, we would encourage you to consider joining today. And the URL at the bottom of the screen is how you would do that. It's very easy. So today's presentation features Peter Fiske, who I will talk to you about in a second in a little bit more detail, but first some housekeeping. The first portion of our broadcast will be Peter's presentation. Then we will have an open Q&A period at the end. If you would like to ask a question, please type it into the questions panel located on the right side of your screen. You may submit questions or responses through this questions panel at any time during the webinar. You can also open and close the webinar panel with this little orange arrow that you see on the top left. And you can also choose your computer audio or phone using the panel on the right. Finally, a link to the recording of today's presentation will be emailed to you. You'll get a follow-up email that will contain a link to that recording and will also be made available on the webinar page. Please allow 48 hours for us to upload that video. And yeah, we also encourage you to complete the survey upon exiting so that APS Webinars can improve its ability to provide you with these valuable services. Okay. Whoops. Next, I'm going to introduce our speaker, who is actually he just wrapped up another event and he's just now joining the call. So I see him joining. That's great news. So Peter Fiske is the Executive Director for the National Alliance for Water Innovation, a coalition between labs, universities, and U.S. water companies committed to developing game-changing technologies to enable distributed desalination and water reuse. He has also assisted in the development of many startups, and his work has spanned private sector, national labs, and government agencies. And I'm going to make him the presenter right now while I finish introducing him.
Thank you very much, Crystal.
Absolutely. Welcome, Peter. Glad you could join us.
Thank you.
Yeah, he is also an excellent public speaker on careers and professional development for scientists, author of the book, Put Your Science to Work, and has been a colleague of mine in this space for nearly 10 years. So Peter, I'm going to let you finish sharing your screen and turn things over to you.
Good. Okay, I'm going to move this, make that smaller. All right. You can see all my screen and just my screen, right?
Yep, just the screen. It's in full screen mode. Looks great.
Okay, well, here I am. Hi, everybody. Gosh, Crystal, we're at the end of a set of webinars we've been giving. You know, frankly, we started this a year ago when COVID happened and we had to pivot the spring 2020 meeting online. And then you and I have done a whole bunch of webinars together on a variety of subjects related to careers, career development, entrepreneurship, strategy, etc. And so we are rounding out this whole series with a final discussion of IP, intellectual property. And you ready to go, Crystal?
Yep, sounds great, Peter. Looking forward to it.
Okay. So for starters, for those of you who have not been on any of our webinars yet, just a little bit about me. I'm a geochemist and material scientist by training. Did a postdoc at Lawrence Livermore Lab, worked in the White House for a year, went back to Lawrence Livermore, got an MBA at UC Berkeley, and then left the science world for 18 years to get involved in a series of startups, including my first and then my second, Pax Water Technologies, which we then sold in 2017 and gave me the opportunity to come back to the world of science. So lesson number one, you can go back. And in fact, the things I learned outside the lab were incredibly valuable for me back inside the lab. And the things I learned inside the lab were amazingly valuable for me outside the lab. So no matter what pathway you take in what direction, let me tell you, it'll serve you well. So let me start for all of you. I think that we have a chat window, right? Crystal, are people able to access the chat window?
It's called the questions panel, but yes, everybody can.
Everybody open up the questions panel. I have a question for you. Panel. What is an invention? What is an invention? Please write your answer in the questions panel. What is an invention? Crystal, tell me some of the answers we're getting so far. What is an invention? Or you can answer too, Crystal. What's an invention?
Well, we've got some responses coming in. A marketable new product,
Okay.
a discovery, something that's new and improves quality of life. I love that one.
Okay.
A novel idea for commercial application. Yeah, so lots of things coming in.
Good. Okay. It's often something new. And in our world of physics, it's often something technical. So you told me what an invention is. Everybody, what's an innovation? What's an innovation compared to an invention? Crystal, what do you think the difference is between an invention and an innovation is?
Well, gosh, Peter, that's a good question. I would say I think of an invention as being an applied use of existing knowledge to solve a problem, whereas an innovation is kind of a brand new way of thinking about the problem. But we got other things coming in. Innovation is the act of innovating. I like that one.
That helps.
Yeah. Someone says it can be totally unmarketable, even if it's a new idea. Implementation of innovation is an invention. Okay. I like that one too.
Okay. So an innovation is something that's new, but it's also useful. And some of you picked up on this. It often disrupts the established way of doing something. And the reason I want to bring up a distinction between invention and innovation comes very much back to your training as a physicist instead of what you started off here, because the value systems in academia versus industry are very different, and therefore it causes us to think about this issue somewhat differently. So in academic culture versus industry culture, in academic culture, we focus on discoveries that are interesting, and we work on things that are interesting, and maybe they're interesting to us and maybe the handful of other clients in our sub-discipline, but we focus on the best discoveries which are interesting, whether or not they're useful. In industry, they focus on the best discoveries which are useful, whether or not they're interesting. And so the difference between these two is focusing on things that are interesting often leads to invention, a new way of doing something. Figuring out what of those things actually lead to something useful is the key to innovation. So I want to start our discussion today about intellectual property by helping you understand this contrasting difference between invention and innovation. An invention is something by definition that's new, but for it to be an innovation or potentially to lead to a product, it has to have some utility. And we're going to get back into this theme because this is at the heart of what intellectual property is. So academically, we can do stuff that's really interesting and very complex. We often love stuff because it's complex, but it may not actually represent something that is useful, especially in the marketplace. Now, don't get me wrong, it is possible to come up with a blockbuster innovation in the laboratory. It's been done before. And here's an example. I don't know if the name Alistair Pilkington rings the bell for anybody. Alistair Pilkington. Well, Alistair Pilkington had a breakthrough about this stuff, glass. Because up until the 1940s, the way we made panes of glass was by literally blowing large bubbles of glass and flattening them out. And so old houses and old windows, you commonly see this rippled texture to the glass. And that is not because that's an artistic choice. That is because the existing ways of making panels of glass before 1940 were very much oriented around blowing bubbles and then flattening them out on a flat surface. It was very inefficient, which is why windows have these little panels and these things called mullions between them, because you couldn't make panels of glass very big. Well, Pilkington came up with a really interesting invention in 1959 called the float glass process. He had a bath of glass in this panel, note at section 6 here, and the vat of molten glass would dribble over onto a lake, a bed, section 9, of molten tin. And because this was a liquid on top and this was a liquid on bottom, you ended up with extremely flat, atomically flat surfaces. This is called float glass. This is the dominant way in which we make glass today, and it was an absolute physics revolution. Very simple insight. If you have two liquid-liquid surfaces together, they will be very, very smooth. Now, you know what the impact of this innovation was. Instead of small panels of windows and mullions, we have buildings, entire structures built with carapaces of glass. We use glass everywhere. And so this represents an example of a major innovation, completely disrupted how we made glass previously. Now, why didn't, once Pilkington made this invention, why didn't other existing glass manufacturers copy Pilkington? The answer is very simple. Pilkington had a patent. And that patent, well, what is a patent? I'm glad you asked that question. It turns out that the idea of patents occurred to people way back in the medieval era. And in Venice and in parts of Europe, there were early deals that rulers struck with certain manufacturers to give them essentially monopoly. Only maker of Parmesan cheese in my area. You're the only maker of horseshoes in my area. So the king or the ruler granted a monopoly right to one particular manufacturer. When the founding fathers set up the US Constitution, they realized that they should also enshrine in our Constitution some guidelines for how to promote commerce. And they created in Article 1, Section 8, the idea that we should promote the progress of science and useful arts by allowing for legal opportunities for monopoly. Now, today's intellectual property law, or IP law, recognizes different types of intellectual property. We have patents, which I just talked about, and that is typically a right granted by the government to the inventor to prevent others from making, using, or selling an invention for a period of time, and in exchange for publishing the invention. There is also a different type of intellectual property that you can also legally protect called trademarks. A trademark is a seal, sign, design, or expression which signifies a specific product or service from one particular source and differentiates it from the other. The third type of intellectual property, which you may also encounter as a scientist, is copyright. A copyright is the legal right that grants the creator of an exclusive work exclusive rights to determine when the original work may be used. And in fact, you commonly encounter copyright when you submit an article to a journal for publication. They actually ask you to sign over some of the copyright to the journal so they can reproduce it legally over and over again. The final type of intellectual property are trade secrets. These are formula, practice, process, ways of doing things that are not generally known, and they represent some of the most valuable intellectual property that companies hold. And think about it this way. the formula to Coca-Cola is one of the most closely held secrets, and it has never been patented. Why don't they patent the formula to Coca-Cola? Well, because then people would know exactly what's in Coca-Cola and they could make a product that is slightly different than Coke and not charge the same price. So in some cases, it makes sense to file a patent. In some cases, it makes sense to keep something a trade secret. We'll talk about both as we move forward. And by the way, I want to encourage you as we go forward to open up the questions window and put questions in there as they come to you as we talk about the subject of IP and patents. And we'll get to those questions at the end. So let's get back to this question, what is a patent? Well, basically a patent is a deal. It's a contract between an inventor and the government, and there's a quid pro quo or an exchange. On the one hand, the inventor agrees to teach or disclose the subject matter invention and how to use it. In exchange, the government then says, we will then give you a right to exclusivity for a period of time. That whole exchange, teaching what the invention is and how it's used, and granting someone exclusivity is the nature of filing and achieving a patent. Notice that a patent doesn't obligate you or give you a right to practice an invention. The patent simply gives you the legal right to demand that somebody else who's practicing your invention cease to do so. So it's a negative right. Now, what is a copyright? A copyright is protection to the author for creative works in everything from art to literature to software. This is where it often comes into play in doing science and doing physics. The copyright protects the form of expression rather than the subject matter. So in other words, rather than a patent on how to deconvolve a certain spectra, a copyright would be for the specific computer program and lines of code that spell out how to operationalize that deconvolution. It gives the copyright owner 5 exclusive rights. The copyright owner has the right to reproduce it, has the right to prepare derivative works, has the right to distribute copies, and perform and display this publicly. So that's really interesting if you think about it. This is, again, why a journal might ask you for the copyright, because they want to be able to republish your journal article over and over again. The copyright arises automatically upon creation with little to no cost. So the only thing you have to do in copyright is generate original material. And you don't necessarily have to register it, but you can register it with the US Patent and Trade Office. Now, what's interesting about copyrights is whereas patents only last a maximum of 20 years, copyrights last for a long time. In fact, they typically outlast the oldest living author. There's typically, across the United States and across the world, a range of time even after the author dies for that copyright to remain in effect. So you are granted copyright automatically when you create a work. And that means whether it's a song that you write, or a piece of computer code, or a circuit design, or even the design of a specific component, that is part of copyrighted material. And all you have to do is write copyright at the end of it. So then how is that different than a trademark? Well, as I said, a trademark is a specific symbol. It's a specific word or image that conveys, and it can even be a sound, believe it or not. Sounds? Yes, sounds. It conveys the identity of a company or a product. And so it's designed specifically to avoid confusion in the marketplace. So you might have, if you've ever traveled abroad and occasionally you've seen versions of like Mickey Mouse. These are attempts to emulate Mickey in foreign countries. They are trying to essentially evade a trademark. By the way, Mickey Mouse is trademarked. And the reason companies invest in trademarks is that it expresses the identity of the company and then associates that symbol with the brand or the reputation or the quality of that company. And by the way, trademarks can often be licensed. So for example, McDonald's restaurants are not owned by McDonald's. They're owned by individual business people called franchisees. They've purchased the right from McDonald's for the arches, for the Big Macs, for all the cups and all the equipment, and they set up the business and run the business. So in order to have a trademark granted, you have to use it, and you have to use it in commerce. So you have to show the US and Patent Trade Office, here is the symbol on the side of my coffee cup. I am using this in commerce. I therefore petition the US government to recognize it as a trademark and allow me to prevent other people from using something similar. The last type of IP is something that's often not discussed, and it's called a trade secret. What is a trade secret? It is simply information in the course of an operation of a business or an experiment that affords particular economic advantage because it's not publicly known. So in other words, it's sort of like a recipe or a better way of doing things. And it can also be a formula, a pattern, a program, a device, a method, a technique, or a process. But instead of registering with the government and making that deal, that quid pro quo with the government, where you teach everybody about the invention, in exchange the government gives you protection for 20 years, a trade secret you hold to within your company, and you don't tell anybody outside the company, and that's great. The challenge is you have to keep that trade secret and protect it as confidential. In fact, if you fail to keep the practices in place to make it confidential information, you can lose the rights to your trade secret. And mostly people are rigorous about trade secrecy because of misappropriation or theft. And the answer, the dilemma about trade secrets is that somebody can in fact patent one of your trade secrets. You've been operating for years with a particular way of doing something, you haven't told anybody, and lo and behold, somebody in another company patents something that is exactly that technique. And they can do that because you have had to keep it secret, and they can go ahead and patent it. It doesn't protect you against independent discovery. Whereas a patent, if you have a patent for something and somebody independently discovers the same thing, they cannot violate your patent. You already have the rights to that invention. It also doesn't expire. In fact, what typically happens with a trade secret is it just gets old. It ceases to be useful, you move on, you develop an even better idea, and the trade secret quietly becomes of no value. Now, the reason I bring this up is that all these four areas are things that you're going to encounter as a scientist, whether or not you stay in academia or stay in the research world and move off into the private sector. And so part of what we wanted to do here today was give you a little bit of intellectual property and patent 101, so that you understand both the mechanisms in the United States of how patents and intellectual property work, but also how you might structure and even conduct your career with a better understanding of what IP is. Okay, so let's take a look at a patent. By the way, Google Patents is the easiest platform by which you can go in and do complete comprehensive searches about patents. And by the way, one of the things they don't teach you in grad school is that the patent literature represents a very interesting and important set of references that researchers in academia and in physics often don't ever evaluate. We're very used to going on, the scientific and peer-reviewed literature and going through an exhaustive search, looking at the past references related to a topic that we're studying. But almost never does a research scientist go over to the patent literature and just see what is present in patents. So I encourage you to do that every time you're working on a specific technology. It can be very informative. So here's an example of a patent. This is actually one of my patents, and it has several key parts to it. The key parts to a patent are, first of all, something called a specification. It's often written as description, but the legal term is a specification. The specification is what you as an inventor do to hold up your side of the bargain. You teach everyone about the invention. You explain what the invention is, why it's valuable, and how it works. That's called the specification, and you have to do that as part of obtaining this patent. You also often have to provide a lot of very detailed drawings that itemize the particular elements of the patent. But the legal part of a patent is not in the drawings and not in the description per se. It's in this third area called claims. The claims are a very specific set of legal terms that describe exactly what your patent lays claim to. And in fact, while a patent description might read very much like a journal article and talk about the history of an invention and the various, it may even include figures and diagrams explaining the history. Fundamentally, the legal aspect of the patent is in the claim set. And I don't want to go into any more details. There are plenty of other elements in a patent that you might learn once you get into this field if you begin searching for patents. But right now, those are the top three: the specification, the drawings, and the claims. You draft these, sometimes with the help of your employer. You submit them to the US government, the US Patent and Trade Office, and then you go back and forth with the US Patent and Trade Office, essentially them asking you questions or denying some of your claims and you rebutting those denials. So one of the things you see here is often in the front page of a patent, you will see a set of dates and a set of actions that describe the specific steps that the inventor and the USPTO took to arrive at a set of claims that the USPTO would grant. And that's what those dates show. So you can see on this patent that there is a previous patent that this is referring to, and that we applied for this secondary patent in 2018, and it was granted in 2020. Now, how do you get a patent? What is a necessary set of ingredients to get a patent from the US Patent and Trade Office? One of the key elements of a patent has to be what's called novelty. Invention is not new if it's already known to the public, and it can be found in what's called prior art. Prior art is very much like what we call references in the peer-reviewed literature. Prior art is all the information that's previously been disclosed. It's not just the published information in journal articles, etc. It might be brochures or even public statements, web pages, PhD theses might include descriptions which were publicly disclosed. If they've been publicly disclosed sometime in the past, you cannot patent it. It's no longer novel. Now, it's very often the case when inventors first come across an idea and they render the idea, they say, hey, this is a great idea. They begin looking and they find, in fact, oh my God, it's already been patented. The answer is people may have discussed certain aspects of it, but it's often the case that even with something that was largely invented before, there might be a few novel elements that you can identify. And that's one of the tricks that you work with a patent lawyer on. So I know the obvious question for people is, well, how do I tell somebody about my invention and avoid it becoming prior art against my patent? That gets into the subject of NDAs, or non-disclosure agreements, and we'll talk about those later. Okay, the second requirement for a patent is non-obviousness. Not just novelty, but non-obviousness. What is non-obviousness? Non-obviousness is what a person who they say skilled in the art, skilled in the relevant technical field would consider to be not obvious. I know that sounds like a bit of a circular diagram, but basically what the test is that the US Patent and Trade Office issues is, would somebody who has knowledge in this field and has all the prior art available to them, would the patent that you've got be obvious based on all that prior art? If the answer is it's non-obvious, then you have the ability to obtain a patent. So usually obviousness is something like making something smaller or larger, or changing the shape or the color of the size, making it faster or slower, or taking an invention in one industry and simply applying it to another industry. Those are not non-obvious. Those are incremental things. They aren't inventions. Non-obvious things are typically characterized by something like an unexpected result. So for example, when somebody discovers that 2 hydroturbines instead of 1 eliminates crossflow and reduces damage to the turbine. That wasn't known. Somebody skilled in the art was using a single turbine. We've discovered that 2 is better. That's non-obvious. Another way of testing for non-obviousness is if you can see in industry or in the technical area that there's been a long period in which there's a need, a long felt need. There's evidence that nobody's had a solution to this problem. If there was a solution to the problem, it would be here by now. The lack of a solution indicates that my invention is non-obvious. It hasn't been invented yet. And so those results, those tests there are actually part of what goes on in the dialogue between you as the inventor or your lawyer representing you and the US Patent and Trade Office. There are other requirements for a patent. It has to be useful. It has to actually have some identifiable benefit and is capable of use. So the pizza holster, not so much. And public principles, it can't be something kind of silly or offensive. So that's not patentable either. Now, why do I bring this all to your attention? As a young scientist, you might have been thinking, well, I'll never get involved in IP, I'll stay in academia, blah, blah, blah. Well, the answer is you already have. You already have. And the reason I know this is that you have signed an employment agreement. When you joined your graduate school, you signed a bunch of papers in that first week. I know that was like getting your withholding set up and getting your stipend and blah, blah, blah. But one of these pieces of paper was an employment agreement. And employment agreements commonly have terms in them that relate to intellectual property. So it's almost always the case that an employment agreement has some sort of stipulated part of the agreement, which is about who owns the IP. So even for students, even for grad students, when you sign some of those forms, you register with the university that if you are doing research on a particular subject funded by the university or funded by the government through the university, the subject matter inventions that's part of that come out of that research, your employer has the first right to those inventions. Now, some employers, including universities and national labs, have formal reward programs for successful inventors. So if you have a patent, or if you have 3 patents or 4 patents, some employers actually reward you. Sometimes people can get an annual bonus based on having patents issued. In many cases, if you have a patent, even as an employee in a company, and that patent ends up being licensed or has valuable royalty revenue associated with it, you might actually be granted a small share of that license revenue. And then the other thing that employers commonly do is they give you recognition, which is nice. Kind of tell you that you're hot stuff for filing these patents. Your employment agreement may also dictate some specific things around secrets. Now, as I said, remember, patents are things you disclose to the government and are published. Trade secrets are things and ideas you don't disclose. And so in industry, it's almost always the case that your responsibilities as an employee in your employment agreement include your responsibility to guard company intellectual property, as well as the intellectual property that belong to your company's partners. And so whether or not it's patented, maybe it's some piece of sensitive information like a list of customers or test data. Those materials are almost always confidential. And I will tell you that it is most often the case that technical employees, when they move to a new job, if they have a dispute with a previous employer, it's over something like a trade secret, not a patent. So I have most often seen the case that an inventor changes jobs or quits their job, and the employer makes a claim that the invention that they're using now was something that, strictly speaking, should belong to the company that employed them at the time of the invention. Now, what's interesting about universities don't really have trade secrets, and that's for an obvious reason. Universities are in the business of publishing. They're in the business of teaching. So this is not a place where secrets are created. If you come up with something that is very valuable, you can choose not to publish it. You can even choose to try to patent it. But the universities typically don't obligate you to hold things secret. They do often say that if you have a potentially marketable technology, that you are obligated to disclose it. And that's where we get into disclosure agreements and non-disclosure agreements. So you may sign one of these as part of your employment agreement. In fact, if you are working in industry, you may always sign one of these as part of the first day at work when you join the company. A non-disclosure agreement is an agreement between you and the other party that a certain set of information will stay confidential and you will have responsibilities. Now, you may, in the course of some dialogue with another partner, another university, or another industry partner, might be confronted with needing to sign a non-disclosure agreement. This is very commonly the case when university researchers partner with industry, because that industry partner wants to make sure that if they share sensitive or non-public information with you, that you don't turn around and publish it. And so they try to put together what's called a non-disclosure agreement to define the specific things that you shouldn't share with other people. By the way, when you go visit a tech company and you sign in and get your badge in the front, you may also be signing an NDA, believe it or not. So look at the fine print as you're filling out your badge. They may actually have you click some boxes saying that you will not disclose any information that you have seen during your visit during the day. Now, there's several key terms in a non-disclosure agreement. The first one is, who are the parties? Who is the agreement between? Okay, it's typically between you or your company and them, a person or another company. Another common term in the NDA is the purpose of the disclosure. Why are you sharing confidential information with each other? You're sharing it maybe because you are writing a grant together, or you're sharing it because you intend to do some collaborative research together, but there needs to be a purpose of the disclosure. Also, there is commonly a term. How long is this NDA going to last between us over this particular bit of information? And then finally, there is often in the NDA a very clear set of responsibilities that are outlined. What does each party have to do to maintain this non-disclosure agreement? And for example, one of the most common things that's stated in a non-disclosure agreement is that you have to mark the documents covered by the NDA with something that says confidential. So literally, when you see confidential on a slide or confidential in a set of documents, that is showing you that the other party or your organization says this page is covered by our non-disclosure agreement. This page should not go out to other people. A very, very common mistake that scientists can make is they get a set of slides and they have a bunch of slides, and one of the slides is from a confidential deck, and they copy and paste the slide into another deck. This is why I strongly recommend, if you ever get into the situation, to keep this slides segregated so you know which slides and which information are confidential. Another responsibility that's often expressed in the NDA is that you have to literally destroy the documents at the end of the NDA or return them to the other party. Which is kind of funny, because all this stuff is just attachments in email anyway, but yep, at the end of the NDA, you are agreeing to get rid of those documents. By the way, nobody does. I mean, everybody forgets. It ends up being an attachment buried somewhere in your email. So, typically NDAs last for between 2 to 5 years. And this is also another important thing about secrets or trade secrets. And that is, they have a pretty short half-life. They're just not very valuable after a period of time. Now, one thing that I find a lot of scientists are uncertain about is how your choice of communicating affects intellectual property and your rights to intellectual property. The number one reason why potentially valuable innovations from academic institutions can't be patented is that they're not novel. In fact, somebody has done this before. And in the course of searching through the literature, through the prior art, you discover that in fact, somebody disclosed this idea earlier. But the number two reason why potentially valuable innovations are not patentable is that you previously disclosed them yourself. And what is a disclosure? A disclosure is any public presentation. So let's say you gave an APS talk and you showed the graph and you talked about how you did the deconvolution. That statement, even if it's verbal, if it gave the details of how you did the deconvolution, you can't subsequently patent the deconvolution. That is already public disclosure. A web posting, certainly submission to a journal. This is why it's often the case when you have a publication ready for submission, you typically send it in to a portion of your university and they ask you, is there any potentially patentable invention described in this publication? Most of the time people say no, but sometimes they say yes, in which case they say, before you submit this publication, let's register and file for IP protection. Now, the other way you can inadvertently disclose and invalidate your ability to have a patent is telling somebody outside your organization, somebody who's not covered by the same employment agreement and IP responsibility. So within your organization, you can typically assume that everybody in your organization is governed by the same non-disclosure and agreement that they shouldn't disclose. So you can tell your colleagues, but when you tell people outside your firm about it, that is a disclosure, and that could potentially invalidate the claims for a patent. So I know you're sitting there thinking, okay, wait, how can I talk about my innovation without talking about my innovation? So the first answer is don't talk about it, or talk about it in vague or general terms. A better way is to talk about it in terms of its capabilities and results, not the method or design, and to show results or samples. So when you talk about this novel deconvolution method, you can say, we used a novel deconvolution method. We were able to deconvolve these spectra, which would normally take 20 hours using this level of computational power. We did it in 5 minutes, and the details of that is something that we are pursuing IP on. In fact, it's very reasonable, even in a technical talk, to explain that a portion of this represents subject matter invention that you're pursuing IP protection for. People are usually very respectful once you kind of know that there's some details you can't share with them. So invention disclosures. Your employer usually has written policies about disclosing inventions. You typically, as an employee, have an obligation to report in a very specific process whether you've invented something that you think is novel. You're usually not required to report inventions that are totally outside of your scope of work. So let's say you, every Tuesday night at open mic down at the coffee house, you have your muon wrap. Don't have to worry about that. That's not patentable by your company or trademarked. But you should often be very careful that anything you invent using company resources could be the subject of an invention disclosure. So if you have an idea for something outside your field, but you're using the university's computer systems and you do a whole bunch of work on the computer systems, even if it's not part of your current work scope, because you used company resources, the claim to that IP could reside with your employer, not you. And so this is just a general caution about how to be careful. So a general thing is, at a certain point, somebody always has a subject matter invention that looks good enough that they contemplate, maybe I should start some outside business. And that might be a great idea. But I'd simply suggest that you try as soon as possible to make sure that you segregate the resources between what you do on the outside and what you do inside your job or inside your university. So don't use company resources for your outside gig. Get your own computer. I have my own computer. That's what I always use. And I do it for that reason, because I sometimes might want to work on something not related to my life at Lawrence Berkeley Lab. Another key obligation that's often in employment agreements is that if you start earning money from an outside gig, let's say you start consulting on deconvolution, you have to tell your employer. And the employer typically wants you to do two things. They want you to disclose of any potential conflicts of interest. That is to say, oh, I may have a financial interest in this business or this activity, and therefore you should know that in case we have any decisions we need to make that involve that company. The second thing that an employer will want is a conflict of interest mitigation plan. And this is essentially just a written plan for how you intend to keep the two activities separate. I won't do this work on university property. I won't do this work during these hours. If I have to take calls, I will go outside in public areas, things like that. And your university, your employer has templates of these documents. They often have a very well established process for putting conflict of interest and interest mitigation plans in place. Now, in universities in particular, and some national labs, some form of outside compensation is very typical and it's non-problematic. So honoraria you get for speaking or for writing and royalties from publications, those types of income, sometimes you disclose them, but very often, even if you disclose them, the university does not have any rights to that income. Similarly, it is not unusual for researchers in academia or in national labs to have some amount of outside consulting business. Maybe it's technical consulting. There, with a conflict of interest disclosure in place and a conflict of interest mitigation plan, a university or national lab might be perfectly okay with you doing substantial amounts of consulting activity. In some cases, some technical areas, there is a professional practice where you might be earning money. So for example, MD PhDs in the biomedical world, it is not unusual for MD PhDs to simultaneously have a research position at a university and be doing doctor work and actually, treating patients and billing patients. So there are environments where it's very common for people to have a professional practice. Civil engineers are another area where it is not unusual for a civil engineer and professor at a university to also have an outside professional practice. So, what's an invention? Let's wrap up and just review here. What is an invention? An invention is something that's new, but an innovation is something that's new and is useful and often disrupts the established way of doing something. And the reason I think this is important is that how do you know if things are useful? Because the value systems in academia and industry are different, right? The academic culture versus the industry culture. We work on the best research, which is interesting. They work on the best research that is useful. Novelty, that is to say something new, is rewarded because you can't publish on something if it's not new, right? Anything that's not new seems to be seen as trivial, but in industry, introducing something brand new can actually be problematic, believe it or not, because you introduce new, untested ways of doing things and potential new ways of breaking things. In the academic culture, complex solutions, complex arrangements are interesting, they're valued, simple things end up seeming trivial and uninteresting. In industry, it's just the opposite. Complex solutions end up having a lot of ways in which they can break. Simple solutions are often much more valuable because they have fewer ways in which they can break. And so in just wrapping things up, we have an idea that we have this thing called the Valley of Death, which is science and academia operate on this side of the valley, creating science and showing things are possible, and universities and industry operates on the other side of the valley, where they try to commercialize products. And between the two is this uncomfortable period where an innovation might have potential, but there's a lot of investment necessary. And frankly, most of the stuff that's valuable is stuff that's in your head. This is a plot from UC Berkeley. It's sort of a notional diagram showing in the university the relative amount of know-how versus inventions that are disclosed versus inventions, disclosures that are patented, patents that are licensed, licenses that turn into products, and products that turn into revenue. Most of the valuable stuff that you know is actually in your head. And that's very valuable because, you may have something very insightful, but you don't know if it's insightful or useful until you find out. How do I know if what I've invented is useful? You got to get out of the building. You got to get off the university campus, and you've got to get out there and talk to people who are trying to solve those real world problems. Maybe your invention is an innovation. because it enables them to do something better, cheaper, and faster. Or maybe not. Maybe it's just an invention, which is novel and new, but maybe not so useful. I will also tell you that you now have access to a wonderful tool that I didn't have when I was in graduate school called NSF iCore. This is a new program that's running in many universities. It's funded by the National Science Foundation, open to any NSF-funded scientists, and it's an 8-week program that helps you explore through customer discovery interviews exactly whether your invention represents an innovation. Does it have utility? Does it have value in the marketplace? You may recall, for those of you who have seen some of our previous webinars, Crystal and I have posted some of the webinars from last summer that relate to issues about customer discovery, value proposition, and even business model candidates. So you can go back into APS's archives and look at some of those past webinars and learn more about how we do business model analysis. It's a 7-week course. Yes, Crystal.
Peter, real quick,
more about that?
there seems to be some issues with the bandwidth on your end, and the slides are not advancing. We're having a hard time seeing the slides. I don't know if you can do anything about it, but just letting you know.
I'm so sorry. Well, guys, I apologize for that. We will be able to give you access to these slides afterwards, and there is a recording. So I will try to advance as gently as I can, but the AT&T gods are merciless sometimes, and I'm sorry that that's the case now. NSF iCore is a 7-week program. It has a kickoff workshop and a lot of time in a very intense way for you to learn more about how to achieve an insight as to whether your invention is an innovation. I see that my audio connection has been lost, so that's my audio connection has been restored. That's good. NSF's iCore program is distributed across the nation. Many universities have NSF iCore programs. And I will just wrap up. We will now talk about questions and answers. I hope you guys enjoyed this introduction into IP. I'm sorry if some of the audio has been spotty, but I'm now going to stop sharing slides so that we can return to our Q&A. And Crystal, why don't you tee us up with questions that have come in so far in our discussions today?
Yeah, we've had a lot of questions actually, Peter. I don't know how many we're going to get through, but hopefully we'll get to some at least. So relating to what you were saying, this was kind of said earlier in the discussion, but related to what you were saying about industry versus academia, someone says that they have brought university funded projects back into companies because of IP opportunities. And he says, less instrumentation related research. I am sometimes confused why universities spend so much money on patent applications. Thoughts?
Sure, plenty of thoughts. Well, first of all, universities, when they receive government funding, one of the conditions that government agencies have is that universities make an attempt to recognize inventions and to get them commercialized. So there is an obligation that the funding agencies have to promote technology commercialization. So that's one reason why universities do it. Some universities also make a lot of money, but sometimes they're for surprisingly simple patents. Like University of South Florida, I think, had the patent on Gatorade. They make a lot of money on Gatorade, right? That's not terribly technical. Some medical schools have a lot of revenue that comes in from inventions from medical practice and biomedical technology. And some leading universities like MIT and Stanford have a thriving licensing and royalty revenue stream. So smaller universities often feel like, well, if the big boys and girls can do it, surely we should be doing it to some extent. So those are some of the motivations why universities try to commercialize their technology. But your question suggests that you may be aware of a simple secret, and that is most universities do not even recover the costs associated with their commercialization efforts. So most of the time they're doing this as a loss leader because they have to do it, because they want to do it, And you never know. You know, you roll the dice sometimes, you might get the double box stars and have a big invention that might actually be valuable for your university. But thanks for the question.
Two things really quickly. You might want to try not sharing your video, and also just to help with the bandwidth. Yeah. And so one person said, could we please see the UC Berkeley slide regarding winnowing versus stage? Is there any way you can try to advance to that?
I can. Let me see.
Let's see if it actually changes on our screen. And we have time maybe for one more question that came in. So far, we're not.
This, what they were saying. How does this look? Can you guys see this?
We can see the NSF I-Core team course.
Let me go and try again. Can you see this? Go to webinar.
Oh, no.
I do not love you today, go to webinar.
Well, okay, Peter, tell you what, folks, let's see. You know what? Peter can give a copy of his slides to me, and I can email them to you. So yeah, we have your name and registration.
Yeah. Anybody who anybody who wants to copy the slide, they should request to you, and then we can get.
You know what? Don't even bother. I'm just going to send it to all of you. I'll just don't bother sending me an email.
Okay.
If you send them to me, Peter, I will share them with everyone. One more question while we have a minute left.
You bet.
What is the cheapest way to get a patent?
The cheapest way to get a patent is to do as much of the work as you can yourself, doing a good job of prior art searches, going to Google Patents, identifying all the potential patents that overlap, doing a thorough investigation of the prior art in journal articles, etc., preparing all that information as much as possible, and then finding a qualified IP attorney in a part of the country that's not as expensive. So I will tell you that the law does not change, whether you are a lawyer in San Francisco or a lawyer in Kansas City. However, the hourly rates are substantially different. So this is one little pro tip. I strongly encourage people to find IP counsel who are in less expensive parts of the country, or to find small practitioners as opposed to large law firms who have higher costs. So those are the ways. I don't recommend people filing patents by themselves, only because the marginal savings in doing so is not that great, and the potential to screw it up somehow is just very, very large. And so I just always recommend at a certain point, you can do a lot of the prep work, but having a qualified attorney take responsibility for filing and for prosecuting your patent is often really valuable. It's worth it.
Yeah, we actually have a webinar that we did some time ago with a patent lawyer, and I've been to a couple discussions with them. And yeah, the filing process is really complicated, and if any aspect of it goes wrong, it's bad. So yeah, great. Okay, Peter, I think that we are definitely out of time for the official webinar. We apologize if we did not get to your questions. And again, for the technical issues, this is our world, spotty Wi-Fi and whatnot. But anyway, you can certainly follow up. You can send an email to webinars@aps.org, and we'll try to forward your questions to Peter for answers. As we already mentioned, this was recorded. I am going to just preemptively send the slides out to everybody. Like I said, we have your email address, so that's no problem. And the recording will be uploaded both to the webinar page as a YouTube link that you can watch at any time. It'll also be attached to an email you'll get from GoToWebinar in about 48 hours. And lastly, before we all go, I'd like to remind you all to please take a moment to fill out the survey at the end. We really do appreciate your feedback. It helps us continue to improve our broadcasts. So with that, I'll say goodbye to Peter.
Thank you, Crystal. Goodbye, everybody. And look forward to future webinars with you.
Yeah. All right. Thanks, everybody. American Physical Society, copyright 2021, all rights reserved.
See, she did that. You see that, everybody?
That's right, copyright. Bye-bye.